I'm a trust and estates attorney at Epstein and O'Donovan. We're in Portland, Maine. And today we're going to be covering a long-term care and asset protection planning. Um, Always have to do kind of the attorney disclaimer as far as this material is meant to be educational. For this type of planning in particular, it's really important to work with an attorney. I feel like there are a lot of traps for the unwary. But kind of the goal of my session today is to give you an overview of the public benefit that covers long-term care, the financial eligibility rules, and some of the planning options that are available. That way, if anything sounds like it applies to you, you can kind of take that next step of doing, especially some of this proactive planning. Just an overview of what we're going to talk about today. Again, we're talking about the financial eligibility rules for MaineCare, which is the public benefit that pays for your care, long-term care. And there's three big topics we're going to cover. It is a means-tested public benefit, which means you can only have so much income and assets in order to be eligible. So we're going to go over the major income and asset rules. And then there's something called the look back period and estate recovery. We'll dive into those in a minute, but those are the kind of the three most important parts of the financial eligibility rules that you really need a basic background on in order to understand the different asset protection planning strategies. We're also reviewing them because states have slightly different rules. So sometimes people come to me and they're like, I found this blog post. It said X, Y, and Z. It's not necessarily that there's a lot of misinformation out there, but because states have different approaches, there is sometimes bad information for Maine. And so again, really want to focus on what are those common strategies to shield your assets from your long-term care costs. Want to throw in the disclaimer, couple more disclaimers. One, these strategies are currently permitted under federal and state law. I know there's a lot in the news this week about Medicaid. I'm not going to be discussing any of that. Right now, what I'm discussing is current federal and state law. And Linda and I were joking beforehand, if there's any big changes, we'll be back and doing one of these in a couple of months. The other disclaimer I like to throw in is, again, we're going to be talking about how to take advantage of certain rules to shield your assets from your long-term care costs. And a couple of years ago, I was doing one of these presentations and I got to the end and someone raised their hand. I was like, well, that all sounds highly illegal. And so I just want to make clear, and we'll get into this, that whenever we're talking about applying for public benefits, you have to give a lot of information over to the state in order to become eligible. So everything we're talking about is not, oh, let's have you do this and see if no one will find out about it. It's all stuff that's going to happen in the open. And so, yes, everything that we're talking about today is current law. Again, I wanted to throw in some kind of foundational terms. So Medicaid is the umbrella term for hundreds of federal public benefits programs that are then administered by the state. So Medicaid in Maine is known as MaineCare. And the two most common MaineCare programs you're going to hear about are the long-term care benefit program, but also there's a health insurance benefit program, which is outside of the scope of what we're talking about today. You've also probably heard of Medicare, which is a federal health insurance program, also outside of the scope of what we're talking about today, but I wanted to include them because all those terms are very similar and it does get confusing. So today we're talking about Medicaid / MaineCare for long-term care benefits. And I should say too, before we dive too quickly in, because I'm going to do kind of a surface level overview today. The slides might have more information that we're able to cover, but Linda's going to send them around along with the video after, so you'll have them kind of as a resource. So again, just as an introduction, again, MaineCare is what's called a means-tested program. So again, you can only have so much income and assets in order to be eligible. And the benefit we're talking about pays for long-term, your care in a nursing home or, for you or a loved one, a nursing home, assisted living facility, and some in-home care benefits. How an attorney can help you, as an attorney can help advise you on how to preserve your assets and still become financially eligible for these benefits, which is what we'll talk about today. We're focusing on financial eligibility, but you also need to be medically eligible. And that's something that's done through what's called a Maximus assessment. And we'll talk about that in a little bit. The first topic we're going to cover is income. This is the most straightforward part of this program because in order to be eligible for MaineCare, your income needs to be less than the monthly cost for, if you're living in a nursing home or assisted living, the monthly cost of care. So the average monthly cost of care that I could find for a semi-private room in nursing home in Maine is currently over $12,000 a month. So I've never had a client who had more than $12,000 a month in income. So folks usually satisfy this rule easily. Even if you're collecting like annuities or a pension. The only thing to point out is there are some specialized MaineCare programs. For example, there's a program, it's called the Brain Injury Waiver Program. They have a different income rule. So, it can differ depending on the program, but for long-term care benefits, it's a high bar, fortunately. I wanted to point out what happens when you do, kind of jumping ahead a little bit, but I think it's important to let people know that if you do end up receiving MaineCare benefits, your income actually goes to the facility as your monthly contribution to your cost of care, and the state pays the balance. Again, something people aren't always aware of, and so I wanted to point it out. You do get to keep some of it, depending on if you're married and you have a spouse who's still living at home, you can keep some of your income for them, and there's a formula of how they figure that out. And there's also, you can keep some money for your health insurance premiums and a very small personal needs allowance. But that's what happens to your income kind of down the road. We're going to focus today on treatment of assets because that's really what the type of planning people are looking to do. And again, some of this you've probably heard of if you've done a little bit of reading on the topic. So in order to be eligible for this benefit, you can only have $2,000 in countable assets. So that's very, very low, with an additional $8,000 allowed in a savings account, or I've had DHS treat this as just like $8,000 in other assets. So in total, it's typically thought of as a $10,000 asset limit. For married couples, the community spouse, so the spouse who does not need the benefits, is permitted to keep an unlimited amount of assets if the MaineCare spouse is in assisted living, and $157,920 if the applicant is in a nursing home. That number was set and then adjusted for inflation, which is why it's a random number. Important to point out that when DHS is reviewing assets that are jointly titled are presumed to be entirely in the name of the applicant. So a little bit more on assets. All assets are divided into countable and non-countable assets. So the most important and common non-countable assets are someone's primary residence if their equity in it is under, this year it's about $1 million. Prepaid funeral plans, household furnishings. If DHS had to tally up everyone's clothes and household furnishings, it would be very hard to process those applications. So that's not counted. One vehicle of any value. I've had people have really nice RVs be their non-countable asset. But everything else is countable. Checking, savings account, IRA accounts, a second vehicle, assets in a revocable trust, all going to be countable assets. So high level, but that's the overview on assets. There is something called the look back period. And what this means is when you apply for this benefit, DHHS looks at, they're going to collect financial statements and other data on your financial transactions for the 5 years before you apply for the benefit. And they scrutinize all transactions over $500, and they will penalize gifts. And so the reason for this is that DHHS doesn't want people to intentionally impoverish themselves in order to be eligible for the benefit. And so this is really important to know because there are planning opportunities to take advantage of if it's likely more than 5 years before you or your spouse, or if you're helping a parent, needs this benefit. So a little bit about how this the look back period works. So if you do end up making a gift within 5 years of needing the benefit and needing MaineCare, there are some exempt transfers, which we'll get into on the next page. But if it's not an exempt transfer, the transfer will be penalized. And the way I'll give you a hypothetical to kind of show you how the penalty works. So let's say you give away $50,000 to your son. Sometimes people get confused with there's an annual gift tax exclusion of $19,000 that has nothing to do with MaineCare. So any gift is going to be penalized, except for small, like birthday gifts, graduation gifts, Christmas gifts, small infrequent gifts I haven't had issues with. Let's say you give away $10,000 a year to your son for the 5 years before you apply for benefits. And now you have in total a $50,000 gift. DHHS will take that amount of money and they divide it by the penalty divisor, which again is adjusted for inflation. So this year it is $11,363. To keep the math simple, we'll say the penalty divisor is $10,000. They'll take the gift, divide it by the penalty divisor, and the number you get, which in this case, 50,000 divided by 10,000 is 5. You didn't know you'd be doing math today. That's the number of months that you are not permitted to receive the benefit when you are otherwise medically or financially eligible for benefits. So what that looks like is you could have fewer than $10,000 in countable assets and be medically eligible for the benefit. But if you've made a gift, you have to somehow privately pay for those 5 months before you can start accepting MaineCare benefits. And the policy reasoning behind that is the state is saying, hey, if you hadn't given away $50,000, then you would have those funds available to pay for your care. So we always need to be dealing with this pretty harsh rule. Worth pointing out in Maine, not in every state, but in Maine, you can cure a gift. So for some people, they've given a gift away to a child, and then the child is able to give it back to them. The gift is treated by DHHS as if it never happened. We talked about those exempt transfers. So those are really important. The biggest one is that transfers between spouses are fully exempt. So if, let's say, someone needs assisted living care, and they have a community spouse who doesn't need that care, who's going to stay at home, they can transfer all of their assets into their spouse's name. Doesn't work for retirement assets, but any non-retirement assets. So assuming the retirement assets are spent down, then they can apply for MaineCare. Other exempt transfers are, and we're going to talk through some more hypotheticals in the back half of the presentation. Gifts to a minor child or a disabled child, technically gifts to anyone with a disability. There is a caregiving child exemption that is really hard to get. So if an applicant has an adult child who moves in with them and cares for them for the 2 years before the individual needs this benefit, then they can transfer their house to that child, and that's not a penalized transfer. The reason why this rule is hard to use, I had a client in the past who moved in with mom to care for mom, was there for 18 months, and then mom's health really declined. And he ended up moving her into nursing level care for her safety. Because it was 18 months and not 2 years, he wasn't able to take advantage of this rule. And obviously transfers for fair market value are not considered transfers. All right, so that's very, very surface level. Those rules are complicated, but I think it's really important to know, because when I start talking to people about this type of planning, they're like, well, I'll just give everything away and then I can apply for benefits. And so it's not as important to know the nitty gritty of how the transfer penalties are assessed, but it is important to know that the transfer penalties exist. Again, last topic on financial eligibility that's so important to know is that there's something called estate recovery. And this is not the case with most public benefits, but for MaineCare benefits, um, let's say a woman has, she owned her home. It's an exempt asset. So she moved into a nursing home and received MaineCare, and then she passes away. The state is allowed to put a lien on her real estate to recoup the benefit that was paid on her behalf. This is a very harsh rule. It's set by federal law. Um, there are some exemptions, like there's no estate recovery if there's a surviving spouse or a disabled child. But for most families, it's a very tough thing to deal with. So a lot of the planning that we do is also trying to shield assets from a state recovery. Because even if you can get eligible through exempt assets, you might then have to deal on the back end with a state recovery. And the state pays, they don't pay sticker price, but I just saw a bill for assisted living. They were paying almost $5,000 a month for someone's assisted living benefit. So as you can imagine, that adds up quickly. And unfortunately, in Maine, a state recovery can also seek recovery from non-probate assets. So we really have to be intentional with our planning to shield assets from a state recovery. So again, those are the three big topics: income and asset limitations, look back period, and estate recovery. And again, each of those has its own complexities, but if you don't know, especially that the look back period exists or that a state recovery exists, people end up doing things that seem good at the time but might have harsh consequences down the road. Again, very briefly, I think it's worth pointing out the life cycle of a MaineCare application. Again, doing this at a very high level. But when an application is submitted, so you're medically and financially eligible for benefits. And let's say you're working with an attorney, since obviously that's my experience, so I kind of know how that works. You're submitting, you're under asset, you're submitting your application. In order to be financially eligible for that month, you need to have less than $10,000 in countable assets in one day of the month. So, today is the 29th of January. If you are under asset on Friday, you can have your benefits be backdated to January 1st. When you submit that application, it triggers what's called a maximus assessment that determines your medical eligibility for the benefit. It's worth pointing out, if you're not receiving benefits at home, if you're moving into assisted living or a nursing home, the facility often can start that process sooner. And if a facility has determined that you or your loved one is medically qualified to live there, I've never had a maximus assessment come back differently. After you submit your application, DHHS is going to send you a letter asking for supporting documentation. And I think it's worth pointing out that there's typically a very short deadline, to the point that sometimes I've gotten these letters in the mail after the deadline has expired. You can ask for an extension. I can't recall if it's 30 or 60 days. I think it's technically 30 days, and then you have an additional 30 days. So it's still a pretty short window of time. And then after that, you get your notice of decision. For the income rules, that limit of you can't have too much income in order to be eligible, the state follows what's called the name on the check rule. So it's not household, it's just the income that's going to the person who's going to be applying for MaineCare. So for example, if you have a married couple and they both get Social Security and they both have pensions, it's only the MaineCare applicant, the person who's going to receive the benefit, whose income matters. So for married couples, if one person is applying for benefits, that person is treated as the MaineCare applicant, and their spouse is called the community spouse, no matter where they live. So if the spouse lives at home, great. I just worked with a married couple where they were both in assisted living, one of them receiving MaineCare benefits and the other one, or I think one was a nursing home. I can't remember exactly, but one of them was privately paying. And so community spouse just means the spouse who's not receiving MaineCare benefits. Let's talk again, very high level, about the asset protection planning strategies. We generally summarize them as the do nothing approach, the wait and see crisis planning approach, and the proactive planning approach. So The do almost nothing approach is if you take no action, then the person applying for benefits will spend down their assets on their care until they're below the $10,000 asset limit. And as long as they've made no gifts in the look back period and are medically eligible, they can begin spending benefits. The most common strategy you can do here is to what's called a spend down strategy. So sometimes we have people who are very close to eligibility. They just maybe have $50,000 or, are over that asset limit. And you can purchase, take your, money in a savings account, for example. And we're assuming we've exhausted all of our exempt transfers. So let's say this is a single applicant who still has too much in a savings account. What you're going to be looking is how to convert those funds into non-countable assets. So most common strategies are paying off any debt. If you still own a home, then, does it need a new roof? Does it need new windows? Does it need a new boiler? Things along those lines. If we don't have a vehicle, purchasing that vehicle, that's a non-countable asset. Putting, $10,000 into a prepaid burial plan, that's going to be a non-countable asset. And I should say, even this simple kind of do nothing but a spend down approach, you should do with an attorney, just because if you do this and miss an asset and then you're over asset for the month, then you have to privately pay for that month. So that's the do almost nothing approach. Proactive planning, that is kind of the bread and butter of what we do. And I didn't mention this at the beginning, so I'll mention it now, is when I started in practice, I worked at a firm that just did kind of MaineCare planning. And so I've done all of this different type of planning. My firm now is a full trust and estates firm. So we don't just do MaineCare planning, but the most common planning we're doing is this proactive planning. So what does that mean? Proactive planning is planning that takes place more than 5 years before the potential applicant needs benefits. So outside of the look back period. And the most common proactive planning strategy is to gift your assets, because gifts outside of the look back period are not reported to DHHS and do not result in transfer penalties. So often we're talking about to clients about the different ways to make gifts. The most common one I'm asked about is, can I gift my house or an asset directly to a family member? The pro of this, like deeding your house to a child of yours, is that it's very cost effective, just the cost of the deed. But there are lots of downsides and kind of traps of the unwary. I was just talking to an attorney this week who had a married couple. They gifted their house to the daughter, and then the daughter got divorced, and the house was subject, it's considered the daughter's asset, so it's subject to her divorce. And I think it had to be sold. I don't really know what the end result was there. But you have, an outright gift. You have no control of the asset after it's gifted, subject to a family member's debts or divorce, and you have no step up in basis. So, I think most of you probably know what that is, but just to cover it, and I'll use real estate as an example. Your cost basis in your house is what you purchased it for. And typically, if someone's inheriting an asset, they will get a stepped up basis, meaning they will get their basis will be the fair market value for the real estate on the day you passed away. And if they sell it, they won't owe any capital gains tax on that sale. If you gift your asset to a loved one, they don't get your stepped up basis. So if you bought your house with the way the real estate market is going now, even if you bought your house 10 years ago and you gift it to your child, and then down the road they're trying to sell it, they may owe capital gains tax on that. So a little beyond the scope, but really worth pointing out. The most common tool we're using is an irrevocable Medicaid compliant trust. So it's not just any trust that will work. It's a gift to a trust, but it has to be this specific type of trust. The benefit of it is, for real estate, you maintain the right to use the real estate through a life lease for the balance of your life. You have the privilege of paying the, maintenance costs and property taxes, but the asset is shielded from the debts of your kids or beneficiaries, and they do still receive a step up in cost basis at your death. The con is that with this type of trust, you can't be trustee of the trust. So you really have to have trustworthy kind of family members or individuals to serve as trustee if you're using this type of plan. Some important features, again, can't be trustee. You are entitled to the income from the trust and you pay taxes at your tax rate on any income. Like I said, you get the step up in basis. If you sell your home from the trust, you preserve that capital gains tax exclusion that we all have on our primary residence. So you keep that. You may lose a homestead exemption, which is a small tax break that you get each year. But most people think that's a good trade-off for shielding their house from the cost of, or other assets from the cost of long-term care. And the way that works is if it's more than 5 years before you need benefits, or if it's fewer than 5 years, but you have other assets to pay through the 5 years, the assets in trust are shielded from the state. Again, like we talked about, really requires reliable individuals to serve as trustee and as beneficiaries of trust principal. So you technically cannot be a beneficiary of the trust assets besides the income. But if you ever needed to undo the trust, it would have to go out to that family member and then back to you. So again, really, really need trustworthy individuals in that role. Again, very high level, and we're almost done, so I'm gonna save, we'll be able to get into some hypotheticals and I'll take questions. The last thing you need to know is you also have what's called crisis planning. Crisis sounds scary, but it just means that if you or a loved one all of a sudden need MaineCare benefits or need assisted living and nursing level care, there is planning you can do. And the way crisis planning works, again, a little beyond the scope of the presentation because it's complex, but typically you can preserve about 40 to 50% of the value of non-retirement assets through this type of planning. It does require often selling real estate assets. And it does often require, for example, if the applicant has dementia or doesn't have the capacity to execute a trust, it often requires that the MaineCare applicant have a power of attorney that has trust creation authority and gifting authority. So that's another estate planning tool that's very useful in this type of planning because you need an agent who can act on your behalf in regards to your finances. Again, I think I'll take questions on that, but I wanted to make a plug for other professional resources you might need with this type of planning. So again, attorneys help with your financial eligibility for long-term care, but we work closely with financial advisors because we're not financial advisors and we need to take into consideration your specific financial goals. Case managers, if you're helping a loved one who has a lot of need, they can help manage, beyond just being eligible for the benefit, they can help manage their care. There are organizations that help with assisted living facility searches, just figuring out like which ones have good reputations, which ones have availability of where should I put my name on a wait list. Worth talking briefly about long-term care insurance. The best long-term care insurance policies I'm seeing were purchased many decades ago. It's still possible to purchase one now, but often people are finding that the premiums are not worth the benefit that's paid. And then I just want to mention dementia and Alzheimer's support. There are organizations in Maine. A place to start is the name of one down in Kennebunk, that if you are caring for a loved one with dementia or Alzheimer's, there are resources there to help. So I just want to wrap up the presentation part by saying, my contact information is here. My firm does a lot of work on the proactive planning side of things. We do not do crisis planning because that is very involved planning, and there are a couple firms in Maine that almost exclusively do that. So to the extent that you know of someone who needs care very quickly, we do keep a list of attorneys that we work with that do that type of planning, kind of point you in the right direction. Really important to make sure that you're not just working with a real estate attorney or even a trust and estates attorney, but a trust and estates attorney who does this type of planning specifically, to see that your specific, they'll have to read through your specific trust. Is there a recommended asset level to begin the trust process? Nope, definitely not. I mean, this is something that there's no minimum or I'm like, not that there's a maximum, but as you go higher up, the less likely is that you need to do this planning right away. So a common client I used to work with was just folks who their primary asset was their equity in their house. So no recommended asset level. Someone said, please define non-retirement assets. So for retirement assets, we are not putting those in trusts because there are lots of downsides to having retirement accounts in trusts. But that's why it's important we work with the financial brokers. More recently, it's become more common that retirement assets, people are potentially converting them into like a brokerage account because they're retired and they'll pay taxes at their low income rate, but maybe their kids are high earners. And if they inherit them, they're going to pay taxes at their higher income bracket rate. So that's why we separate out planning with non-retirement and retirement assets. What is the less likely higher up amount? I had an attorney who I started working out with, and he had done MaineCare planning for someone with $9 million. So there's not an upper limit. It's just when you get to having literally a couple $1,000,000, it's like, what is the benefit of doing that planning? But that's why it's important to at least have the consultation and kind of walk through the pros and cons. Yes, it's about passing money down to the next generation, and it often comes up with like I'm most often seeing it with someone who's the bulk of their assets are in real estate. So like someone has, I'm working with someone right now that someone has had a beautiful family house on the ocean, right? And they don't want to have to sell that in order to potentially need MaineCare. And it's something they inherited. I mean, it's been generations in this family. And so we want to make sure they're protecting that from the state in order to pass it down for the next members of the family to use. Anything that's placed in a trust more than 5 years before you need MaineCare is shielded from the state. Yeah. The problem with this planning, or not problem, is like none of us have a crystal ball. So when are we going to need MaineCare? When are we going to need this type of planning? Is the hard part. So often, and we can touch on this, but often I'm talking to people about this when they're approaching retirement, just to get the conversation started. And for there's no specific age on funding the trust, but it's not unusual to do that for couples and individuals who are like maybe 70. But the sooner you can get started, at least with the conversation, the better. I know our firm, for example, if you come in to get an estate plan done, I will send you we'll talk about this planning, and then I'll send you a letter. It's like 5 pages long. So you have this reference guide of this type of planning, how it applies to you, your different options. That way you don't have to, do anything right away, but you have some guidance on how this can help your family specifically. There is a National Academy of Elder Law Attorneys. And so you can look up through that database, and I think National Academy, there we go, there's the acronym, an attorney in your area if you have a loved one in Florida to do this type of planning, because it is different from state to state. The Alzheimer's group I was talking about in Kennebunk, not a law firm, just a nonprofit. I think it's called A Place to Start. And their biggest resource is they have a monthly community calendar, and you can go and have lunch with other people who are caring for loved ones with Alzheimer's and dementia. You can bring the person you care for. It's very informal, just meant to be a resource. So you have other people to kind of connect with who are going through a similar process. Liquid assets can go into a trust. Non-retirement assets, I should say, should go into the trust. Again, the reason why we're not putting retirement assets into this type of trust is because, I think it's just not allowed. But you also need to be looking at the tax consequences of dealing with IRAs. That's why the financial advisors are so important. Oh, this is a good one. If the home is moved into a trust, can it be sold to purchase another home? Yes. So if you have a home, even if it has a mortgage on it, there is a federal law that permits you or it allows you to transfer your home with the mortgage into the trust, and the bank cannot call in the loan. Usually, if you have a home with a mortgage and you just try to give it away, the bank can collect the loan, but not with this type of trust. Um, the only issue is it's very difficult to refinance once it's in the trust. And so I'm usually talking to people about if you want to refinance down the road, now is not the time to do it. But let's say you don't have a mortgage, or maybe you do, you put the home in a trust and you sell it because you're downsizing. The proceeds will stay in the trust protected, and you can use the proceeds to buy replacement property. That's a great way. That happens pretty often in that scenario. Someone has owned their home for a long time and then they're downsizing, and that's permissible. Let's see. The name again of the law list in Florida. So NALA, the National Academy of Elder Law Attorneys, is the website that has a search function for elder law attorneys in Florida, and you can search by zip code, because I think it's, a lot of people do consults on Zoom now, but it can be nice to find someone in your area. Someone asked about cost, and yes, the lawyer answer is it depends. So often when we're doing proactive planning, we're doing an entire estate plan for someone, the wills, powers of attorney, advanced healthcare directive, and then this trust and a deed, and a life lease. But the trust on its own typically is, I think, about between $2,500 to $3,500, depending on what other documents we're doing. And the value of that is just, hopefully shielding the bulk of the trust assets from your future long-term care costs. Someone asked if there are specific long-term care programs or homes for veterans. There are veterans long-term care facilities in Maine that are, and I don't know the eligibility rules for living there, because I think it's veterans and spouses of veterans. It's worth reaching out to them directly about wait lists and things like that, because I know there's one in Scarborough, for example, that I think has quite a long wait list. There are also veterans benefits that cover long-term care costs. That's not something you have to get a special certificate to do that type of planning. And you can't, actually veterans are entitled to those legal services. I don't think they can charge for that. I don't know off the top of my head, but I know there's someone in Maine who does that type of planning. And if I think of it, I'll send it to Linda. If not, it's a matter of just asking for someone who does that specific type of planning. And yes, $2,500 to $3,500 is an estimate of the total cost. So we bill all of our time at an hourly rate. So that would be like the consult, the drafting, any follow-up conversations. If we're retitling, like moving a deed into the trust, then the recording fees, things like that. And then the meeting to sign.